So we started live and I'll record the session as well. Okay. Thank you everyone for joining us. We're going to have a discussion on the implications of the term ethnic cleansing in our conversations on genocide. My name is Adana Alic. I'm a senior at the University of Connecticut. And it's my honor to introduce Dr. Gregory Stanton and Jennifer Kirby-McLemore. Dr. Stanton is the founding president and chairman of Genocide Watch. He also founded the Cambodian Genocide Project and the Alliance Against Genocide. He contributed to the UN Security Council resolutions that formed the ICTR and was the president of the International Association of Genocide Scholars. His 10 Stages of Genocide model is taught in genocide education classes all over the US. Ms. Kirby-McLemore is a legal associate with Genocide Watch. She has worked at the office as the office manager event coordinator for the Center for Judaic Holocaust and Peace Studies. Now, as a legal contributor at the Genocide Watch, she assists in the organization's effort to advocate on behalf of victims of genocide. They will present their arguments for removing ethnic cleansing from the legal lexicon by discussing its complex and confusing nature within society, as well as international criminal law. Without further ado, Dr. Stanton, if you want to start.
Thank you very much. It's a great pleasure to speak to you here, sponsored by the University of Connecticut. I gave my very first speech on genocide concerning the Cambodian genocide at the University of Connecticut Law School when I was still a law student at Yale Law School. So this is what you call a complete circle now. And it was a speech about the genocide that had been committed by the Khmer Rouge. At that time, I dedicated my life to bringing them to trial. And everyone at the time and many of the human rights groups and governments said, well, that's impossible. We don't even have a court. Well, it wasn't impossible. And I want that to be a lesson to every single student who's listening to this, because I started the campaign for that in the Cambodian Genocide Project when I was still a Yale Law student. You don't have to wait to graduate until you begin to change the world. What I want to talk to you today is about a term, ethnic cleansing, that has become a terrible term that is used today for genocide denial. It is a term that was intended to be used for genocide denial by its inventor, Slobodan Milosevic, and the Serbian propagandists. It was a euphemism for forced deportation and genocide. We've just heard a talk by Ellen Kennedy about the genocide of the Rohingya. Well, the UN, the press, human rights groups, and many governments are still calling the Myanmar Army's aggression, genocidal massacres, and forced deportation against the Rohingya, quote, ethnic cleansing, unquote. In every New York Times story you read about it, they call it ethnic cleansing. That is what happened also with Darfur. It's what happened with many other cases since the Rwandan genocide. The term has become a term for genocide denial. Now, what does the term mean? Well, normally, common usage means ethnic cleansing says forced deportation. And in fact, the International Court of Justice even used that definition in its Bosnia versus Serbia case, defining ethnic cleansing as rendering an area ethnically homogeneous by using force or intimidation to remove persons of given groups from the area. It then went on, as you know, to find that the intent of Serbia in Bosnia was not genocide. It was, quote, ethnic cleansing, as though those two intents and those two acts were mutually exclusive. It was a wrongly decided decision. The terms are not mutually exclusive. In fact, genocidal massacres are very frequently used to bring about forced deportation, and that is the legal term that should be used. Ethnic cleansing, in fact, is not a term that appears in the Rome Statute of the International Criminal Court or in any other international treaty. It has no legal meaning in international law. There is no treaty outlawing it. And in fact, even though the ICJ used the term in its Bosnia and its Croatia decisions, the ICJ does not have the power to make treaties. It only has the power to enforce treaties. It did not make international law by using the term. This is a term for which no one can be convicted. No national legal codes prohibit ethnic cleansing. No prosecutor can charge anyone for committing it. Ethnic cleansing is legal. The term is a license for impunity. As it was used by Milosevic, the press, the UN, and policymakers in many governments, the term is used to avoid using the word genocide. Denial frees its user from the duty to take action to stop genocide. That is why the term is used. Now, Slobodan Milosevic invented the term, and along with his propagandists, precisely for genocide denial. And ethnic cleansing is still a term used for genocide denial. Milosevic must be laughing from his grave. Since 2012, the term ethnic cleansing has been the dominant term used for the Rohingya genocide in articles in the Washington Post, the New York Times, the Guardian, in statements by UN officials, and in statements by both Amnesty International and Human Rights Watch. The term has now even crept into UN Security Council statements and the decisions of the International Court of Justice. It is one of the most successful denial terms in world history. In Bosnia v. Serbia and Croatia v. Serbia, the ICJ did not adopt its normal preponderance of the evidence standard of proof. Instead, in both cases, in Bosnia and Croatia, the ICJ required conclusive certainty. It is a standard similar to proof beyond a reasonable doubt in an individual's criminal trial, even though the ICJ is not a criminal court, and no individual can be sent to prison if convicted. In fact, it can't convict individuals. But, and here I quote, the ICJ ruled in Bosnia, the court has long recognized that claims against a state involving charges of exceptional gravity must be proven by evidence that is fully conclusive. And here it refers to the Corfu Channel case. The court requires that it be fully convinced that allegations made in the proceedings that the crime of genocide or other acts enumerated in Article 3 have been committed, have been clearly established. The same standard applies to the proof of attribution for such acts. Now then, applying this very high standard of proof, this imposition of this standard of proof, said the ICJ, means that if any other specific intent besides genocide can be inferred for a state's actions, there cannot be conclusive certainty that the state violated the Genocide Convention. In other words, the court adopted a single intent theory of the special intent to destroy that must be conclusively proven to decide that a state has violated the Genocide Convention. In Bosnia, and here again I quote, the ICJ held, the dolus specialis, the specific intent to destroy the group in whole or in part, has to be convincingly shown by reference to particular circumstances, unless a general plan to that end can be convincingly demonstrated to exist. And for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only, I underline that, only point to the existence of such intent. The Croatian decision quoted and reaffirmed this single intent theory. I could read the quote to you again, but it ends with the very same words. It is necessary and sufficient that this is the only inference that could reasonably be drawn from the acts in question. Now, this single intent theory would make criminal convictions impossible in any criminal court against individuals. If a person pointed a gun at a victim and pulled the trigger, the normal assumption is that he intended to shoot the victim. But if a trial court could not convict him, if any other intent could be inferred, such as robbing the victim, then no murder convictions would ever be possible. In ordinary criminal trials, such a result would be absurd. People have many intentions when they act. To convict a person of murder, all the prosecutor must prove is that murder was one intention, not the only intention for his act. With individuals, this is what is called the Mensrea, the mental element that must be proven for conviction. But what about states? How can you prove the intent of a state? States don't have minds. Mens rea is not a meaningful concept for states, even though Professor Chavez at the ICJ and others do refer to mens rea when they talk about states. For states, the only way to judge their intentions is to assess the consequences of their actions. A utilitarian calculus must be used, not some kind of a psychological or Kantian attempt to know what the state had in its, quote, mind, unquote. For states, a single intent theory is even more absurd than for individuals. With many policymakers, many policies, and many intentions, the adherence of states to their treaty obligations must be judged not by a few statements of leaders or even a few actions, but by the overall consequences of state actions. The false logic underlying the ICJ's Bosnia and Croatia decisions can be traced back to William Chavez's influential treatise, Genocide in International Law, published in 2000, before the ICJ's Bosnia and Croatia decisions. Chavez distinguishes ethnic cleansing from genocide. He treats the terms as if they are mutually exclusive. And I'm quoting here from Chavez. He says, it is incorrect to assert that ethnic cleansing is a form of genocide, or even in some cases, ethnic cleansing amounts to genocide. Both, of course, may share the same goal, which is to eliminate the persecuted group from a given area. While the material acts performed to commit the crimes may often resemble each other, they have two quite different specific intents. One is intended to displace a population, the other to destroy it. The issue is one of intent, and I underline this, it is logically inconceivable that the two agendas coexist. I repeat, it is logically inconceivable that the two agendas coexist. When I first read this fatal error by Bill Chavez in his treatise, Genocide in International Law, I immediately wrote to him. I told him he was wrong. I said it's entirely logical and conceivable that two intents could coexist for the same acts. The intent to forcibly displace a population and the intent to destroy it. They can coexist. In fact, in nearly every historic genocide, the two intentions have coexisted. Genocidal massacres have been used to drive populations out of the territory where they live. Any prosecutor could have told Bill Chavez that a criminal often has more than one intent for his acts and can simultaneously commit more than one crime. In fact, many criminals are charged with more than one crime in the same trial. As he mentioned this morning, in the Derek Chauvin case now being decided, Chauvin has been charged with several crimes. He could be convicted of more than one crime. But Bill has never been a prosecutor. He ignored the fact that individuals and states nearly always have more than one intention for their acts. My letter to Bill went unanswered. Now, please understand, I really like Bill Chavez. He only erred. He didn't commit a mortal sin. I wish he hadn't represented Myanmar at the ICJ, but he certainly did nothing to harm our friendship. In 2009, I asked Bill to succeed me as president of the International Association of Genocide Scholars. I still refer people to him who need counsel in genocide cases, and I still consider him my friend and colleague. But I have been wrong, and I actually think Bill can be wrong also. Bill's own studies of the histories of nearly every genocide should have demonstrated that the perpetrators frequently use massacres intended to destroy part of a national, ethnic, racial, or religious group. That's genocide, in order to terrorize members of the group into fleeing from their territory. That's forced deportation, or as it is sometimes now called, quote, ethnic cleansing. So Bill Chavez, the world expert on the law of genocide and international law, and I must say, yes, he is, has unfortunately become one of the world's foremost genocide deniers. He only recognizes genocides in whole as true genocides. He ignores the in part in the Genocide Convention. He says that the only true genocides in recent history were the Armenian genocide, the Holocaust, and the Rwandan genocide. It's the same mistake that Alain Destex made in his book about the Rwandan genocide. Bill has written that the Ukrainian Holodomor, the Nazi mass murder of Slavs, the Khmer Rouge mass murders in Cambodia, the Sudanese atrocities in Darfur, and now the Myanmar Army's massacres of the Rohingya do not qualify as genocide because they all lack the specific intent to destroy a group. Instead, the intent of the perpetrators was ethnic cleansing, a crime against humanity. I can hear that my West Highland Terrier would like to participate in the conference, so I think I'm going to close the door. Yeah. Now, why is ethnic cleansing used as a term? Ethnic cleansing is used by the press because reporters consider genocide a legal word that can only be used by lawyers. And members of the press are reluctant to use legal terms they are unsure about. Lawyers also are reluctant to use the word genocide. Now, there's several reasons. Lawyers have gutted the word genocide of its preventive effect by insisting on judicial standards of proof of specific intent, and that is the standard of beyond a reasonable doubt, rather than a prosecutor's standard, which is the preponderance of the evidence. That's the standard that should be used when deciding whether or not to prosecute a case of genocide or to say that a genocide is being perpetrated. A systematic campaign of killings and destruction is surely enough proof of intent. But some British Foreign Office, US State Department, European Union, and UN lawyers even claim that only a court can invoke the word genocide. This view is profoundly wrong. It ignores the very name of the International Convention for the Prevention and Punishment of the Crime of Genocide. Courts judge after genocide is over. It's too late for prevention. Genocidal massacres are acts of genocide because genocide consists of acts of genocide intended to destroy, in whole or in part, a national, ethnic, racial, or religious group. You may remember that when the State Department wanted to avoid using the word genocide for the Rwandan genocide, for 3 months it called them acts of genocide as though there was some difference. Well, there isn't any difference. Finally, our Secretary of State, who's a lawyer, cut right through the Gordian knot and said, well, genocide is defined as acts of genocide. And so then we said it was genocide. Genocide is precisely what the Myanmar government and supporting militias have committed against the Rohingya. Myanmar committed both forced displacement and genocide. The crimes often go together. Genocidal massacres are used to terrorize a victim group into fleeing. So we've just heard from Ellen, who, by the way, I greatly admire, and whose World Without Genocide is a member of our Alliance Against Genocide. Over 700,000 Rohingya fled into Bangladesh in 2017, following a couple of 100,000 others who had fled in 2012. And at least 10,000 Rohingya were murdered just in a month in 2017, and over 480 Rohingya villages were burnt to the ground. The so-called international community, which, by the way, I believe exists only in mythology, avoids the word genocide. And I'll tell you why. Because I was in the State Department under the Clinton administration. Policymakers who don't want forceful action avoid using the word genocide. They say it would make them do something. We even had a cable from the Defense Intelligence Agency that said, be careful of this word. We might have to do something. I read that cable. They say it is equally damning to call the crimes ethnic cleansing or atrocities or crimes against humanity. Well, it isn't. They're wrong. Genocide is a more powerful word than ethnic cleansing or atrocities or crimes against humanity. That is why Raphael Lemkin invented it. Because extermination or barbarism or crimes against humanity don't express the horror of the Armenian genocide or the Holocaust. And Lemkin meant it to apply to partial genocides as well as total genocides. So does it make any practical difference if these crimes are called genocide rather than ethnic cleansing? Well, 3 epidemiologists and I in 2007 decided to conduct a study of the effect of using the words ethnic cleansing rather than genocide in 4 recent genocides, in Rwanda, in Bosnia, Kosovo, and Darfur. We counted the number of uses of the terms ethnic cleansing and genocide using one of these amazing tools that Google now makes possible, where you can literally count the words. In the New York Times, in UN press releases, in major law journals, and in statements by Amnesty International and Human Rights Watch. We came to 3 conclusions. Use of the terms has no relationship to the number of people who've been killed. 8,000 killed at Srebrenica was ruled genocide by the ICTY, yet a UN Commission of Inquiry ruled that over 50,000 killed in Darfur when it studied this, and now the figure is probably over 400,000, was not sufficient evidence of intent by the government of Sudan to accuse it of genocide. Secondly, choice of the term to be used is determined by willingness to take action to stop the killing. When the term ethnic cleansing is used, it indicates an unwillingness to take forceful action to stop the crimes. Weak words never motivate the use of force. Indeed, they are probably chosen because the decision not to use force has already been made. And thirdly, it was not until genocide was applied to the crimes that force was used to stop them. This occurred 3 months into the genocide in Rwanda when the US State Department finally acknowledged on June 10, 1994, that acts of genocide in Rwanda were the same as genocide. But the recognition of genocide in that case was too late, as you know. 800,000 Rwandans had already been slaughtered. But that was when the UN was finally willing to send reinforcements to stop any further killing in Rwanda. The same denial emerged in Bosnia. The world press and U.S. called the massacres ethnic cleansing from 1991 until the Srebrenica massacre on July 11th to 13th, 1995. That crime provoked a NATO conference on July 21st, which called it genocide. NATO bombing of Serb forces began on August 30th. The bombing brought Serbia to Dayton to agree to a ceasefire, to division of Bosnia, and a NATO peacekeeping operation. The Bosnian Civil War came to an end. Kosovo was called ethnic cleansing until U.S. War Crimes Ambassador David Sheffer went to the border of Kosovo. I remember talking to him before he went, and I said, "You're going to have to use the G word, David." And he did. He said, indicators of genocide or precursors of genocide are evident in Kosovo. He said it on April 7th, 1999, and his statement was followed immediately by bombing of Belgrade, which brought Serb surrender and NATO occupation of Kosovo. And NATO's still there. I know because I visited my son, who was serving as a Peace Corps volunteer there. Darfur is the exception that proves the rule. Following a careful empirical survey of evidence of genocide among Darfur refugees on September 9, 2004, Secretary of State Colin Powell declared genocide has occurred and may still be occurring in Darfur. We believe the evidence corroborates the specific intent of the perpetrators to destroy a group in whole or in part. Unfortunately, he also said, however, no new action is dictated by this determination. So the U.S. did not employ or deploy U.S. or NATO military forces to stop the genocide. The UN turned around and refused to use the word genocide. The UN appointed its own commission of inquiry led by Antonio Cassese, who, as president of the ICTY, had never handed down a conviction for genocide because he had a very narrow view of the word genocide and of the intent required, a view very much in harmony with the view of Professor Chavez. He detailed many crimes against humanity in Darfur, but he refused to call them genocide. So all that followed were ineffective increases in the African Union monitoring force, but no forceful intervention by UN peacekeepers, by NATO, or any other effective military force. And the Darfur genocide continues. In spite of the improvements in Sudan, the Darfur genocide continues. Since we conducted that study in 2007, ISIS has provided another example of the importance of calling genocide by its proper name. The press, the State Department, the European Union, human rights groups, and the UN refused to call the ISIS atrocities genocide, except the massacres against the Yazidi. Even the U.S. Holocaust Memorial Museum denied that Christians and Shia Muslims were also victims of genocide. So in 2015, Genocide Watch, the Hudson Institute, the Knights of Columbus, Catholic University, congressional staff from both parties, and many other parties, a coalition, formed the Genocide Working Group in Washington, D.C. and London. And we drafted resolutions that were introduced in Congress and in the European Parliament declaring that ISIS was committing genocide against the Yazidis, Christians, Shia, and other religious groups. The resolution passed unanimously in both the Congress and the European Parliament. And Secretary of State Kerry then overruled his legal advisors and declared that ISIS was committing genocide. Our military response was immediate. Action against ISIS was intensified. ISIS was defeated. Appropriations were then passed to resettle the victims of ISIS from the areas from which their victims had been driven. The conclusion, and this is why the term ethnic cleansing must be expunged from the legal lexicon. When the word genocide is used instead of ethnic cleansing, use of force to stop it becomes possible. When the crimes are called ethnic cleansing or crimes against humanity, it is a sure indicator of lack of political will to take forceful action to stop them. Since 2000, the term atrocities, which also, by the way, has no status in international law, has become another indicator of absence of will to take forceful action to stop genocide. Whether or not international leaders decide to use military force to protect the Rohingya when they return to Myanmar, and I hope they don't have to, the crimes committed against them should be called by the proper name, genocide. Maybe then world leaders will recognize our failure to prevent and stop this crime of crimes called genocide. Thank you.
Thank you, Dr. Stanton. You've really started off an amazing discussion on so many topics and issues and really opened a door into a different view that many don't agree with. But thank you for your talk. And now we'll go to Jennifer, if so she can continue on.
Hi, thank you, Dr. Stanton. So I'm actually going to share a PowerPoint, so everyone will just give me a moment to pull that up. And now I have to move myself out of the screen. Okay. All right. So I'm going to continue on the same theme with Dr. Stanton, ethnic cleansing as a term of genocide denial. And I'll start off with a few pertinent quotes. This is the first one by David Tolbert, who said, "The denial is the final fortress of those who commit genocide. Perpetrators hide truth in order to avoid accountability and to submit the new reality by manufacturing an alternative history." Followed by Israel Charney, who said, "We must fight denials because the denial of genocide is a process which is intended to desensitize and make possible the emergence of new forms of genocidal violence to peoples in the future." And before I begin, I'd like to situate this discussion within the broader context of Dr. Stanton's 10 Stages of Genocide model. As you all may be familiar, this model, which is not linear and it moves step by step, it does not move step by step, but rather by a collection of overlapping processes. It concludes with the stage 10, denial. So today, as Dr. Stanton has so powerfully implored us, we'll consider how ethnic cleansing as a euphemism of genocide is used to deny genocide. And to provide a backdrop, I'll summarize the key terminology, which Dr. Stanton has already provided a great demonstration of. I'll explore how ethnic cleansing is used to deny genocide through a criminological analysis, and I'll offer recommendations on how to end the problematic use of the term and suggest that we should instead recognize the term as an indicator of genocide. So since Dr. Stanton has already provided some of the origins, definitions, and law that's applicable, I'll go through this quicker than to not waste anyone's time. So first off, we know that the origin of genocide was Raphael Lemkin. He combined genos for Greek for race or tribe with side, Latin for killing. And we know then that the origin of ethnic cleansing is English translation of a Serbio-Croatian phrase. So moving on, common definitions. So we know that genocide carries enormous meaning. First, we have little g genocide, which is the common label used to describe the most condemnable mass killings, or rather more precisely, the deliberate and systematic extermination of a national, racial, political, or cultural group. And then we have big G genocide, which is a legal term of art that describes criminal liability via the Convention on the Prevention and Punishment of Crime of Genocide. The definitions for ethnic cleansing are a bit trickier. First, there are varying common understandings, and although the term has been discussed within the legal arena for reasons to be discussed soon, it does not have a specific legal status or trigger any mandated obligations. As for common understandings, we have one, the systematic forced removal of ethnic, racial, or religious groups from a given area. which is the one that's used to distinguish itself from genocide. It's when people believe that the intent for ethnic cleansing is merely removal. This would be the one that Dr. Stanton was saying that Professor Chavez and others that have a narrow intent believe. And then, of course, systematic forced removal or extermination of ethnic, racial, or religious groups from a given area. And this is the term that's used by people who assume that the term shares a similar meaning with genocide. So finally, we'll turn to law. As Dr. Stanton said, as for genocide, we have a law against it. The Convention on the Prevention and Punishment for the Crime of Genocide was adopted by the UN and signed and ratified by many countries. And through this law, parties to the convention have a duty to prevent and punish actions of genocide in war and in peacetime. However, as for ethnic cleansing, there is no such law, and therefore there's no criminal liability or obligation to prevent it. So accordingly, given the absence of a legal hook for preventing or prosecuting ethnic cleansing, we need to reconsider what is meant by the term. So we'll look at the common definition again. The systematic forced removal of ethnic, racial, or religious groups from a given area. So when we dig into international law, we find that there's already a law against this, forced removal. The Rome Statute states that deportation or forcible transfer of a population defined as forced displacement of the persons concerned by expulsion or other coercive acts from the area in which they are lawfully present without ground permitted under international law is a crime against humanity, and it's categorized as an act committed as part of a widespread or systematic attack directed against any civilian population. So when this type of action occurred, we should call it forced displacement and prosecute it as such. And as for the second definition, given that when we add extermination, the common understanding is for genocide, then we should call it genocide and prosecute it as such. Therefore, given that there are legal definitions and laws already covering the actions denoted by genocide, by ethnic cleansing, we should stop using the term and replace it with either forced displacement or genocide when appropriate. Because if we don't, we contribute to the growing denial of genocide, as I will now explain through a criminological analysis of the techniques of neutralization. There's been significant scholarship on understanding how perpetrators overcome their morals and principles to commit genocide. This criminological theory is based on the concept of neutralization. It's used to describe how perpetrators were able to deny the reality of their genocidal actions, both during and after the fact. So here I build upon Alexander Alvarez's analysis of the techniques with respect to perpetrators by exploring how various other individuals and organizational actors employ these four techniques to deny genocide by using the term ethnic cleansing. The first technique is the denial of responsibility. Alvarez asserted that perpetrators who are directly responsible for genocide deny responsibility using various defenses, most notably the "I was just following orders" defense that was prominent in the Nuremberg trials. In contrast, journalists, lawyers, academics, and bystander governments' denial is more attenuated. That is that journalists, lawyers, bystanders, and governments literally didn't kill the people in the genocide. However, if we say the quiet part out loud, we'd follow that with, "but we knew it was happening and we let it continue." Thus, the mere existence of this euphemism for genocide, ethnic cleansing, is a way to preach about our condemnation of the behavior without actually having to follow through with the requirements and duties of the Genocide Convention. And unfortunately, we are trapped in this technique of neutralization, our international collective denial of responsibility, because of our status as a group, the international community of countries, media outlets, courts, and universities. It alleviates our individual burden of guilt, because just as individual Nazi SS officers was alleviated by his conformance with and allegiance to his group committing the same behaviors, we feel a similar moral safety in our decision to call genocide ethnic cleansing, because as Alvarez aptly put it, the morality of the groups takes precedence over individual morality, and as long as the primacy and legitimacy of the group remains unchallenged, the individual choice of its members is abrogated. I'll demonstrate further with the following headlines. You're looking at 5 headlines published by various news media and organizations. While referring to and discussing the violence committed against the Rohingya in Myanmar and the Tigrayans in Ethiopia, these headlines, ranging from 2017 to present, each share something in common. That is that they all refer to the violence that we at Genocide Watch recognize as genocide as ethnic cleansing. Now, at best, this genocide denial is unintentional, derived from a misunderstanding of the nuance behind the term. But at worst, the genocide denial is intentional, derived from the desire to avoid triggering the duty to act to prevent, stop, or punish genocide that is required under the Genocide Convention. We'll look first at how journalists and news media commit this technique of neutralization, denial of responsibility. Like many professionals, journalists have a specific code of ethics to which they must conform. They take care to use certain legally obligating terms, not just to protect themselves from liable claims, but also to be sure that they're accurately capturing the facts. But here, when it comes to the term ethnic cleansing, I assert that they're failing to fulfill their professional duty to investigate and understand what they're reporting. That is, they should take the time to understand the international law that informs these crimes and use the term genocide following a legal analysis that establishes either the presence of or explain why genocide is not actually occurring. But instead of using the term ethnic cleansing, they're denying the possible presence of genocide, contributing to the greater misunderstanding of the terms and further harming the victims of genocide. Likewise, human rights non-governmental organizations that fail to use the term genocide are committing similar denials of responsibility. This probably goes without saying, but the failure on behalf of these organizations to call genocide genocide may be most harmful, because these are the ones that should have their fingers on the pulse of such major human rights abuses. Both journalists and governments often depend upon human rights organizations to do the investigating and the reporting, and by reporting it wrong to the world, they're avoiding their responsibility. Finally, we have government and international organizations. The reason governments supplant the term genocide with ethnic cleansing is much more clear-cut, as Dr. Stanton has explained. The objective of the Genocide Convention was to hold the parties to the convention to the obligation to prevent and the corresponding duty to act when the party learns that there is serious risk of genocide. Therefore, governments and the UN alike intentionally avoid the term to circumnavigate the convention's obligations. Some, like in the UK, have even stated that only courts can decide what is and is not genocide, which further denies their responsibility. Recently, we've witnessed this wordplay play out in the international arena with respect to the Uyghur genocide in China. The outgoing U.S. Secretary of State Pompeo made a declaration that China was committing genocide against the Uyghurs. And this announcement put other governments on notice, and subsequently other governments, including Canada and the Netherlands, made the same announcement. And some governments have even enacted sanctions against China following their determination. However, I'm not going to break into this can of worms because, as we know, Secretary of State Blinken and the Biden administration walked back this announcement, calling it instead ethnic cleansing. So this just further explains how complicated this topic is. Having now explained how each type of entity and organization separately denies responsibility through the use of the term ethnic cleansing, let's look at the bigger picture. Because these entities and organizations lean on each other for information and support, we know that they often parrot one another. Therefore, when one uses ethnic cleansing instead of genocide, it gives the other permission to do the same. And by avoiding the term, they contribute to this denial feedback loop, which leads to inaction. Moving on to technique of neutralization number 2, the denial of injury. As Alvarez explained, perpetrators of genocide use euphemisms to conceal their actions and render them acceptable. Terms like special treatment and final solution were used by the Nazis. Hutu perpetrators used the term work to describe the killing. The Myanmar military used the term clearance operations, making the genocide sound like a military tactic or intervention. And China refers to its genocide of the Uyghurs as re-education or de-radicalization, which strips the violence from their action, trying to make it sound palatable. Thus, just as we conceal the horrors of war with terms like collateral damage and friendly fire, we, this international community, perpetuate the continued concealing of injuries of genocide by openly and unapologetically using a phrase generated by perpetrators of the Bosnian genocide, that is ethnic cleansing, as a tool for propaganda and criminal concealment. And in addition, when they use these terms, they're committing either one of two errors. They're either ignoring the evidence of other specific genocidal injuries, or they're failing to give the evidence of such injuries the legal force ascribed by the Genocide Convention. And what I mean is, if they're using the term to substitute for the idea of forced displacement, they're ignoring that killing and sexual violence is also occurring. However, if they're using the term to substitute genocide, they're ignoring the entire subset of genocidal injuries. Neither substitution is appropriate, and both should be stopped in order to accurately acknowledge the injuries suffered by victims of genocide. Technique 3, denial of victim, also referred to as victim blaming or scapegoating. During the Holocaust, the Nazis blamed Jews for a whole host of society's problems, and in so doing, through their propaganda machine, they turned the Jewish victim into the deserving criminal or enemy. When journalists, lawyers, academics use the term ethnic cleansing, we similarly blame the victim, because the term carries with it a connotation that ethnic cleansing is an inevitable outcome of ethnic conflict. And this implies that the victim's own behaviors contributed to the violence and enables outsiders to distance themselves from responsibility, because such ethnic tensions are often so mischaracterized as some deeply historical problem to which there's no solution. This is significant because we know the term was popularized by perpetrators of the Bosnian genocide, a genocide that is often denied as merely a civil war brought on by ethnic conflict. And when we see the term used with respect to Myanmar and Rohingya, we see similar explanations that root the violence in this theory in ethnic conflict. And oftentimes, when if you just Google the genocide, specifically if you use the term ethnic cleansing, when you're looking it up, you'll find these maps that try to point to these ethnic rooted understandings of the beginnings. And technique 4, denial of humanity. Perpetrators use this technique by portraying their victims as subhuman. They use terms like filth, cockroaches, rats, leeches, lice, viruses. And when we see this technique, although dehumanization, what we see with this technique is that although dehumanization can stand alone as a stage of genocide, this dehumanization process also contributes to denial based on the following logical sequence. In genocide, victims are human. If they're not, there is no genocide. The international community's use of ethnic cleansing similarly denies the humanity of victims because the term itself suggests that the targeted group is unclean or subhuman, and therefore warrants such cleansing and does not warrant care and consideration like those of us that are part of humanity. I don't want to leave you without any alternative suggestion for how we would recognize the euphemisms as it relates to genocide. Therefore, I turn now to a comparison across criminal law. Like in genocide, perpetrators of human and sex trafficking use euphemisms, and these can be words or emojis. The airplane is an emoji that's used to designate that the victim is only going to be in a place for a short period of time. The growing heart indicates that it's a minor. The crown indicates that you're speaking to a trafficker. Perpetrators use these euphemisms to avoid detection, while anti-trafficking advocates and law enforcement treat these euphemisms as indicators of trafficking to help locate victims and end trafficking. Some research has demonstrated a wealth of words and emojis and acknowledges that this constant evolution of euphemisms used to avoid detection. So in light of this strategy for detection used in sex trafficking and human trafficking, let us consider ethnic cleansing and its companion euphemisms for genocide. So here I'll just give you all a moment to take in. This is certainly not a list of all cases of genocide, and it's certainly not a list of all of the euphemisms, but just by looking at it, you can see that in each genocide, the perpetrators found other words to describe what they were doing. And it wasn't merely to conceal it from outsiders, but it also is to try to make it more palatable to the citizens, the ones that they, of course, are not trying to kill. So as I bring this to a close, I recommend that we recognize perpetrators' euphemisms as indicators of genocide. And we can do that by funding research to figure out what the euphemisms are and to develop monitoring tracking tools, just like they do for human trafficking and sex trafficking. And then I also recommend that we all stop using the term ethnic cleansing. And we can do that by educating people and calling out those who use the term. And I understand that it'll be an uphill battle, given how the term permeates discussions about genocide today. However, we could begin by educating people about the origins and the consequences of using the term and calling out people who use it. And I'll end finally with this, with another headline. As you can see, it says 3 years later, U.S. pressed to declare Rohingya crisis genocide, hold Myanmar accountable. So what I want to point out here is it says 3 years later. So that's 3 years that we could have been calling it genocide, that we could have been pursuing while it was happening. We could have been pursuing ways to prevent it. And then after the fact, we could have already been pursuing ways to prosecute it. But instead, we waste valuable time by using the wrong terminology. And now I'll open it up for discussion.
Thank you, Jennifer. Thank you for sharing the PowerPoint. It gave us a really great visual on like some of the key aspects of our discussion. So we do have some questions here. So we'll start with like the first one. It's going to be the first question we have here by Tom is, what are the precursors of genocide? In a prior panel, fear, not hate, was discussed. However, weren't there long-standing ethnic tensions and actual systematic discrimination of ethnic Muslims for X prior to the use of propaganda to whip up fears? I believe you're referring to the ex-Yugoslavia in this instance. And there was another question that was sort of similar in the way that can ethnic cleansing be considered precursors to genocide? And is that did the acts differentiate between one another?
Do you want me to start with that? Well, we, as you know, at Genocide Watch believe that genocide is a process. And so when we look for precursors of genocide, we look for specific processes or transformations or operations within a culture that are indicators that we should be worried about genocide. Now, some of the early ones, you know, are not going to be ones that are particularly precursors of genocide. Every society has classification of its people. People are going to call some people Serbs and other people, you know, Bosniaks and so forth and so on. And classification, in other words, is crucial if you're going to have genocide. Symbolization is also important. We have to name those groups and so forth. But, and here's where you begin to get precursors. If you have discrimination, which is what we call stage 3, but it's not a linear model, as Jennifer said. If you have discrimination in which certain groups are really discriminated against, then that's a danger sign, so watch out. And finally, and then when you have dehumanization, that is a real precursor. When you have one group, you know, being referred to as a virus or, you know, some kind of a disease within the country, or rats or cockroaches, things like this. If you have that kind of terminology being used, that dehumanization, then that's a precursor. The next stage we say is organization in the sense of, you know, militias forming. Well, in Bosnia, that was very clear. You had, you know, militias forming in the Republika Srpska and other places. You had also direct, what you could only call gangs forming behind warlords and so forth. You then, those groups try to polarize the society. They try to drive out the moderates. They try to say, if you're not with us, you're against us. And that means, you know, basically making it impossible for anybody who's not with them to even live in the same area or same village. You then actually have planning, for what we call preparation, in which the people who are planning the genocide do it. They plan. And you could see that in the case of Bosnia. There were very clear plans being made, both in Belgrade, in Pali, and other places, for a genocide. And then finally, you have actual persecution, in which, you know, you have groups of snipers sitting on the side of the river up in the hills above the river in Sarajevo, killing people coming through the marketplace. And then when it turns into a major kind of killing, you've got genocide itself. That's when you have actual extermination. And that's when they start setting up the, you know, concentration camps behind barbed wires, the rape camps, mass rape being, by the way, a crime of genocide as decided by the Akiyesu case in the ICTR. I mean, that's actual genocide. So these precursors, they're all warning signs. So when you see them happening, basically you cry bloody murder. You raise hell. And that's what Genocide Watch tries to do.
Another part of that question would be, would ethnic cleansing, in a way, would some argue that it's a precursor to genocide?
Yes, indeed. I think so. I think it is. Yeah. In other words, when there's an attempt to drive certain groups out of the territories they're in other words, forced displacement, yes, I think that is a precursor to genocide.
Okay.
In fact, it goes along with genocide. Just look at what happened to the forced displacement of Native Americans in the United States. You know, Jackson, our president, decided that we weren't going to honor the agreement that Native Americans could live east of the Mississippi. And so everybody has to move west of the Mississippi. And so they had the Trail of Tears, and literally tens of thousands of Native Americans died. It was genocide.
Jennifer, you mentioned some ways, and we can sort of get rid of the ethnic cleansing as a term, or like recommendations on how to improve that. And I was wondering, how does that look like? How does one remove a word from the lexicon, or like how does one prevent people from using it? I mean, yes, calling people out, but how can we see that in a long way? And who makes up these words? Is it the institution that controls what words are being used?
Yeah, I think that your question is the most pertinent question and also the most difficult one to answer. Because that's hard. I mean, if this word, I mean, it really does permeate all of our institutions. How do we begin to get people to stop using it? And so I think, like, I think that the key is educating. So it's having conferences and like this, where we explain why we shouldn't use the word, and then it spreads from there. You know, it's having people, you know, write op-eds when they see someone calling, you know, an act ethnic cleansing. You know, we need to write and we need to correct it and say it's not ethnic cleansing. You should be using the term genocide. So I mean, you start small, but eventually I think that you have to make it part of like Dr. Stanton and I were talking about this yesterday. And we talked about how it's kind of like you need to make it part of woke culture, and that is for people to understand what the meaning behind it and why we shouldn't be using it anymore.
I can think, for instance, of many journalists who have used it in the past, who I happen to know personally. And so when I see them use it, I write them. I write them an email. And it has an effect. You know, they stop using it in some cases. In fact, a lot of cases. Sometimes their editors overrule them and keep putting it in their stories. Then you have to contact their editors, but I find out who they are and I write them. Hannah Beach, for instance, who's been reporting on the Rohingya situation, is a superb reporter. But doggone it, her editors keep putting the word ethnic cleansing in when she writes genocide. And so we had to do that with the Armenian genocide, for example, with the New York Times. Peter Balakian and I, who, you know, is a marvelous, I mean, literally a Pulitzer Prize winning poet in the United States. He's Armenian American. And the two of us went up and met with the editors of the New York Times. And we said, you know, you got to call the Armenian genocide genocide. Stop using these you know, these terms that don't mean what they are. I mean, and by golly, we got somewhere. They now call the Armenian genocide genocide. So I think that kind of campaign, and the Armenians have been the excellent example of how you get that kind of a thing done, because they've had a worldwide campaign for many, many years to get the Armenian genocide called by its proper name, which is genocide. So I'd like to see the American Bar Association pass a resolution saying that we don't agree with use of this term anymore. So please don't use it. Things like that could help. And I think we could, as you know, the Alliance Against Genocide, for instance, could have a working group that of our many organizations. We now have almost 100 members in the alliance, and I think it'll grow far more. Our whole objective is to start a world movement against genocide, just to prevent genocide. And I think that together, and by the way, academic institutions could be hugely helpful here. Students could write, you know, things and could publish them and could put them out in all sorts of ways. So those are just a few ideas.
I know we have some more questions, but we're cutting close to time. So if you guys have many pressing questions, feel free to reach out to Greg or Jennifer later on, and check out some of the recordings on our website. We have resources up there for you as well, and articles from Genocide Watch and from various other scholars to maybe answer some of your questions. But thank you so much, both of you, for joining us and for being part of this great discussion. I really enjoyed it as well. Being Bosnian, I understand how ethnic cleansing becomes a piece of genocide denial. So thank you very much.
Thank you. A great pleasure.
you.
All right. Bye, everyone.